So the judges are not part of the actual deposition, and typically most objections during depositions are reserved until a trial or a later time where a judge would be needed. Sometimes depositions can become contentious and a judge will need to be called in the middle of a deposition and asked to make a particular ruling. But in general, the objections that you make are to form or the nature of the question and are reserved for a later time to be dealt with by the judge at a later proceeding.
Yeah, it's not unusual for a lawyer to object during a deposition, say form objection, or I object to the form of the question. That preserves the record for a later ruling by a judge. But typically in most depositions, unless it's a question about some privileged communication or something that you talked about with your lawyer specifically, the plaintiff is going to be able to generally answer all of the questions and will be directed to answer all the questions. But if there's an objection, a judge will rule on it at a later date.
And it's important for the client to know that they're under oath and that there will be a copy of the proceeding so that their answers to that question are binding for the rest of the case. And if they answer differently later on, that could be used against them in later proceeding.
Yeah, so it's, to follow up on that, it's very important to prepare with your lawyer in advance of the deposition so that when you go into the deposition, you can feel comfortable and feel confident that you're fully prepared and ready to answer all the questions that are going to be asked. Thanks for watching. Hopefully this video was helpful. If you have any additional questions, please feel free to give us a call at 844-RECOVER or visit our website at www.lawyersfortheinjured.com.